Hi, I'm Perry Atkinson, General Manager here at theDove. Hey, check out our other videos and check out our website at thedove.us. Okay, welcome back. Always a delight and an honor to have with us today our good friend Bryan Fischer. He is the Director of Issues Analysis for the American Family Association and a passionate guy in all areas. And well, he's not wearing his 49er blazer, so I don't know if it's a good sign or not, but the season is early, Bryan.
Well, that's right. And the Niners looked good their first weekend out. And unfortunately, my Stanford Cardinal lost to USC on Saturday, so I thought I'd give the Oregon Duck fans and your listening audience a break and not sport my Stanford colors today.
That's okay. We can get you counseling. Don't worry about it. How you doing, my friend? Good to see you.
Doing just fine. Good to be with you.
Good. I want to talk about this L.A. court ruling on same-sex marriages and, in particular, what happened in Louisiana. So is this thing heading to the Supreme Court?
Well, I think it's inevitably headed for the Supreme Court. I think it's going to have to wind up there. And one of the things that's significant about this ruling by this federal judge in Louisiana is this is the first federal judge now, the first federal court that has issued a ruling that has some kind of binding legal effect that actually upholds a ban on same-sex marriage. You've had district court judges that have done it, but you've had this virtual, unobstructed run of activist judges who have overturned bans on same-sex marriage in one state and one court after another. I mean, it was like 19 in a row. So this ruling by this Judge Feldman brings that process to a screeching halt. And what that means now is you have conflicting rulings from lower courts, and that's typically what will trigger the Supreme Court to take up a case. If they've got conflicting rulings from a lower court, then obviously you need to have that resolved. And so I think it's pretty certain that this is going to make its way to the Supreme Court. And, of course, the sooner that happens, I think, for everybody, the better.
All right. Now, why isn't this just a states' right issue? Why would it be? I mean, could the Supreme Court say, hey, you states do what you want to do with this?
Well, and our point all along has been that the Constitution is completely silent about marriage. The Constitution itself does not address the issue of marriage. You go to Article 1, Section 8. It lists all of the enumerated powers that we, the people, have delegated to the federal government, and there is not a single mention of the right or the authority to dictate marriage policy to the states in Article 1, Section 8 anywhere. So that means the federal government, whether it's Congress, whether it's the judicial branch, whether it's the executive branch, has authority under the Constitution to dictate marriage to the states. None. So we believe this ought to be a states' rights issue at the very beginning. And the interesting, in the ruling that was issued by the Supreme Court in the DOMA case last year, they said historically in the United States, defining marriage has always been a matter for the states to decide. So all of these federal courts that have issued rulings overturning bans on same-sex marriage have actually been defying the ruling of the Supreme Court in the DOMA, the Windsor case. And so we are hoping when this case makes its way back to the Supreme Court, that the Supreme Court will uphold its own ruling in Windsor and say this is an issue that belongs to the states. And in so doing, they will uphold the Constitution in every state that has protected natural marriage.
All right, so that forces the states then to define their own constitution as to what a marriage would be. Now, were you aware of what happened to us here in Oregon? Were you aware of that mess?
Well, refresh my memory.
Well, the people passed it fairly substantially that we wanted to define marriage between a man and a woman. We had a gay activist group go after the judge to overturn it, and we had an attorney general that did not even go before the judge to defend the ruling of the people.
Well, and that's happened in a number of other jurisdictions. There are probably at least 6 states where their attorney generals or their governor have decided we're not even going to defend this thing. You know, even though they have a sworn duty, they took an oath before God that they would uphold and defend the Constitution, not only of the United States, but the Constitution of their own individual states. So they were derelict of duty, not even to show up and defend this thing. And that's one of the reasons that these overturns have taken place, is because nobody has showed up to defend the constitutional amendments in these various states.
Bryan, what does your legal counsel tell you? I mean, where is this going? I mean, if it goes to the Supreme Court, and given the makeup of the Supreme Court, you think we got a good chance here?
Well, it's hard to say, and it's going to come down to probably Justice Anthony Kennedy. It seems that all of these controversial issues on social matters come down to Justice Anthony Kennedy's vote. And you take a step back, Perry, and look at the larger issue here. It's just unconscionable. It is just unforgivable. This would be such an offense to the Founding Fathers that we would be at a place in this nation's history where we would be allowing one judge, one man, to establish domestic policy, marriage policy for 315 million Americans. That just violates everything we know about a Republican form of government. But the interesting thing is this Louisiana judge, Judge Feldman, in his ruling, he cited a ruling from Justice Anthony Kennedy in a different matter altogether. Justice Kennedy wrote the majority opinion in a ruling that had to do with overturning affirmative action quotas in the state of Michigan. The people in Michigan went to the ballot box and they said, we do not want race-based quotas in our educational system. And Justice Kennedy said, look, they've got the right to do it. Just because this is a controversial issue does not mean that a court has the right to take away from the people of Michigan the right to establish, to deliberate, to go to the polls and vote on the kind of public policy they want to be recognized in the state of Michigan. And Justice Feldman quoted extensively from Justice Kennedy's own ruling upholding the right of voters in individual states to settle these public policy issues at the ballot box. And so I think Justice Feldman was deliberately targeting his ruling at Justice Kennedy and saying, hey, Justice Kennedy, if you were looking for a basis to uphold your own ruling in Doma and Windsor, here it is. I've laid it out for you in your own words. So if Justice Kennedy issues a ruling that's at all consistent with the ruling he made in the Michigan case, then all of these constitutional amendments in Oregon and every other place, where I think in Oregon it was like 57 to 43, so it's pretty decisive. Like you say, even in a liberal state, 57% of Oregonians said we want to protect natural marriage. I know in Louisiana it was like 78% where this judge issued his ruling. So if Justice Kennedy is consistent at all with his own rulings, his own written opinion, in what's called the Schuett case, that was the affirmative action case in Michigan, then these constitutional amendments will be upheld. They will be reinstated, and these 31 states that honored natural marriage, protected it in their state constitutions, those constitutional amendments will go back into force. And that's, of course, what we hope and pray is the outcome.
Wow. So when do you think this may all occur?
Well, I think the Supreme Court is going to realize that they're going to need to take this up fairly soon. I wouldn't surprise me to see them accept one of these appeals in this coming session. 32 states have sent an appeal to the Supreme Court. Please settle this issue. It's leaving us all in limbo. It's very uncertain. It's making it very difficult for us to craft consistent public policy in our states. So 32 states have appealed to the Supreme Court. Please take this up. Please resolve this issue. We signed a letter from a lot of pro-family organizations making the same request. So I believe it's my sense that the Supreme Court will take this up in this coming session, and perhaps a year from now, we'll know what the Supreme Court has decided.
Okay, so where does this leave civil unions?
Well, that again, if the Supreme Court upholds the right of states to define marriage policy for themselves, then things would go back to the way they were before all of this brouhaha and all of these activist judges got involved. Right. So there were some states that legalized civil unions. Those legalizations would remain in place. What the Supreme Court would be saying, and this is what we hope they say, is this is up to the individual states. This is a matter for the states to decide, and the states can decide, their voters can decide whether they want to recognize civil unions between same-sex couples or not. Now, I personally think that's a very bad idea. Mississippi doesn't allow it. Idaho, where I was a co-author of our marriage amendment in Idaho, we flatly prohibited recognition of any other domestic unions other than the marriage of a husband and a wife. So those states that have done that, then their right to establish that as public policy in their states, that would be protected, and that's what we hope is the outcome.
Okay, this is very interesting. So if it goes back to the states, I mean, I guess let's hope and pray that that does. I mean, that they make that ruling. That means some states, however, could go ahead and say allow for same-sex marriages. Does that still solve the problem if you have one or two states that do it? What kind of an effect that's going to have on us?
Well, here's the reality of it. 31 states passed marriage amendments. That means in 31 states, the voters, the citizens in those states, they went to the polls and said, we want to amend our Constitution, which is the supreme law in our state, to protect natural marriage. Now, it's a very difficult process to revoke an amendment. They would have to go through the same process in reverse. So these states, the only thing they could do then, if the Supreme Court has the right of states to do this, the only thing that citizens in those states could do to go to all the trouble to collect signatures and to put something on the ballot that would revoke. I mean, we've repealed federal marriage amendments. We did with the 19th Amendment. We repealed that. They could do that. But they would have to go to the trouble to do that. Yeah. So it would restore significant protection to citizens to define this issue for themselves. And then states could decide. I believe states have the right to decide whether they will recognize marriages or civil unions that are formed in other states. Because there's Supreme Court ruling that says, look, no one state can dictate public policy to another state. So we should get back to a place where states would only be forced to accept same-sex unions that were formed in other states if their own state marriage policy allowed for that. And that's the way it ought to be.
Well, thank you, Bryan. Thanks for all you guys do there at AFA. And by the way, I want to say to our viewers and listeners, go to afa.net and support what they do. Get in this. It's also an incredible resource for you, afa.net, with all the things they got going on. Bryan, you're a delight and an inspiration. Keep up the good work, and let's stay in touch, buddy.
You bet, Perry. It's always a pleasure to be on with you. Thank you.
All right, God bless. We'll be right back.